I'm Juliette Wolf-Robin, National Executive Director of American Photographic Artists. APA is a not-for-profit trade association of professional photographers run by and for professional photographers. Our mission is to advocate, elevate, and educate the professional photographic community. We have this legal series, a legal lounge that we do every month with Stephen Doniger, who's an attorney who specializes in intellectual property with an exceptional record of success in copyright and trademark litigations. He's an advocate for artists and has worked with APA for many years. You can find past episodes where we talk to Stephen if you go to the American Photographic Artists YouTube channel, and there's a whole series of legal lounge that you can find there and discussions that with him and Jeff Sedlick talking about copyright. So please go back and look for those. You can find out about future talks that we will have on the APA national website or on any of our social media channels. We talk about them there. And we also have a new APA connected community, which is a place where members can talk to each other and ask questions and reach out to us. So check that out. Today, we also have two past presidents of APA National, Jeff Sedlick and Dana Hersey. They're both award-winning commercial photographers, and they've both been involved with copyright small claims. This has really been a long time in the process to get the Copyright Claims Bureau started, to have an opportunity to go to a small claims tribunal. It's online. It allows photographers to present their case without an attorney if they want, and be able to do it in perhaps a more affordable way than going to federal court. It's supposed to be an easier process, a faster process, but we're not sure if that's always exactly what's happening. The process started in June of last year after many years of all the associations representing copyright holders advocating for this, from writer associations, photo associations, illustrators, songwriters, and APA was very involved with that. So we are really interested to see, now that this is launched in June, what does Stephen Doniger, as an attorney, think about the Copyright Claims Tribunal compared to going to federal court? When should you use one or the other? And to hear from Jeff Sedlick and Dana Hersey, their thoughts, what they've seen happening with it, and if it's working as expected. So I will hand it first over to Stephen Doniger, and then Jeff and Dana, if you have questions along the way that you want to ask or comments you want to make, please jump in at any time.
Yeah, thank you so much, Juliette. And let me just start by thanking you, as always, for giving me the opportunity to speak to to APA members. It really is my privilege, and it's a pleasure. And I'm really glad to have Dana and Jeff here, both because I've worked with them extensively in the past and like them, and it's always a pleasure to have conversations with them. But at least equally importantly, because they have at least as much experience as I do at this point with the CCB, which is the Copyright Claims Board. No one really has a ton of experience with the Copyright Claims Board. We're coming up on the 1-year anniversary of it actually opening for business. I think it was in June of last year that it first started, where people could file claims. And in that time, there's been a grand total of one decision on the merits that's come out. And a bunch of people have had not the smoothest experiences with the CCB, which sometimes is to be expected, as there's growing pains of something new. Let's talk it through. Because as you know, Julia, this is something that was a very, very, very long time in the making. As I've been working with APA as its counsel and participating in the coalition calls, it seemed like years of pushing forward, and what's it going to look like, and what can it be, and so at the risk of just sort of being a talking head and just giving way too much information to the people who are tuned in, I do want to give a little overview of sort of what it is and what it's not, and why it is what it is. You know, the first thing to realize is that it's voluntary, and it's voluntary for both the copyright holders who want to make claims through it, and it's voluntary for defendants. So if a defendant says, I don't want to participate in the copyright claims board, they can opt out. The reason for that is that our Constitution gives everyone a right to a jury trial. It gives everyone certain rights that you can't compel them to give up by having this, small claims tribunal. But what it is it's a 3-member tribunal that is designed to create an efficient. If you look at the Copyright Office website, the CCB website, it's supposed to be an efficient and user-friendly option. I'm like reading what they wrote to resolve certain copyright disputes that involve up to $30,000, which are called small claims. So the very first question, Juliet, that you put in this sort of topic of what we're going to be discussing here is when to use the CCB versus federal court. And so let's just kind of go through some of the points of really like what are the differences between the two? What are the benefits of the two? What are they designed to accomplish? And I want to just start out by like noting that one of the main reasons why the CCB was set up is because there were, over the past 20 years, well, probably more than that. I mean, there have been a very significant number of copyright cases filed in federal court. Copyright is exclusively federal. So only federal courts can deal with copyright issues. One of the concerns is that not all copyright cases are big cases. But the federal courts look at themselves as, an important court, with judges that, deal with important federal issues and your major crimes and your major, violations. And the federal courts don't like to look at themselves as small claims courts. And as they get flooded with all of these copyright cases, because quite frankly, there's nowhere else to bring them because copyright is exclusively federal. There was this big idea that something had to give, and we had to create some other avenue to address these claims, and thus the Copyright Claims Board, the CCB, was created. As noted, as we mentioned a moment ago, the CCB, you could deal with claims of up to $30,000 in total damages. And if you're seeking statutory damages, those are going to be limited to $15,000 per work infringed. Now, right there, that's different from federal court. In federal court, if you've got a timely registration and you're seeking statutory damages, for willful infringement, you can seek up to $150,000 per work infringed. For non-willful infringement, you can seek up to $30,000 per work infringed. So you can see that the CCB already cuts in half the maximum statutory damages available per work for non-willful infringement, and it's 1/10 of what's available for willful infringement. But as we know, most cases involving photographs, if it's one work, they generally do resolve for less than $15,000, per image, like generally, not always. So, okay, maybe that's not really an issue. I do want to note there's also a smaller claims procedure that, you can check that box and say, okay, I agree to this small claims procedure, and that has a maximum of $5,000, in available damages. So, let's say that someone uses your work without your permission, and you want to go ahead and you're like, look, my licensing fee on this would have been, $1,200. I want my fees and my costs. Okay, great. Maybe it's like a smaller claim issue. So why would you do that? Why would you decide, let's do this procedure that has a smaller, potential recovery, yeah, my claim might not be worth more than that, but at least in federal court, there's a chance of it. And there's a lot of reasons. The first reason is cost. In federal court, as a general rule, you're going to have an attorney representing you. You can be pro per, but it doesn't usually go very well. The CCB was designed to be more user-friendly and easier for photographers to handle, by themselves. It's designed to be less expensive, more streamlined, less discovery. And discovery is the process by which, once you get into litigation, you can ask the other side for information, they can ask you for information. You can require them to turn over documents, they can require you to turn over documents, answer written questions. And sometimes in federal litigation, especially when you get an aggressive law firm on the other side, it can be really oppressive and very expensive to have attorneys deal with the discovery part of it. So the CCB was designed to be like, there's certain things that you may need for this. It's a much smaller, we're going to keep this simple. We're not going to let discovery get overly, burdensome and oppressive to the extent that we can. So as we discuss sort of the cost savings of those things, the flip side of it is, do you need a lot of discovery? There might be cases where you do. There might be cases where the discovery available to you in the CCB really is unsatisfactory, especially if you think that there may be a claim of willful infringement. Where do they get things from? What do they like? You want to dig into things that might actually lead to a higher statutory damage award. And so your appetite or your ability to handle the cost of litigation is a major factor. Your need for discovery may be a major factor in which you choose. Your ability to travel and whether that's an issue and where the case would otherwise need to be brought is a major issue. And what I mean by that is that the Copyright Claims Board is located in Washington, D.C., but they've set it up so that all the proceedings are handled completely electronically. You're never going to need to travel to Washington, D.C. to participate. You're never that doesn't need to happen. Whereas if you file in federal court, there are specific rules that govern where you need to sue the defendant. And often that's where the defendant is located, either their principal place of business, where they're incorporated. So if you're suing a major publishing company that's in New York and you're located here in California or anywhere else, you may need to sue them in New York. And as a result of that, you may need to travel to New York to take depositions. You may need to travel to New York for hearings. You may need to travel to New York for trial if the case goes to trial. You cut all of that out with the CCB. So that's nice. Beyond the monetary amount, there's also a question of what relief are you seeking? The Copyright Claims Board does not have the authority to issue injunctions, to issue injunctive relief. So if you're suing someone and they won't stop using your work and you need an injunction against them, even if the dollar amount in damages may not be isn't that much, you're going to need to file a federal lawsuit. Sometimes, this is an issue that comes up sometimes with the online service providers when someone serves a takedown notice. And then the other side issues a counter notice, and then if things go back up, and then you can sue them for infringement. But if you want that taken down and they're refusing to do that, again, that may be a reason why you need to go to federal court. Some people may need to file CCB actions just because they can't find an attorney to represent them. And that's the other thing is in CCB, again, I mentioned before, you don't need an attorney in federal court, but because of the way the procedures laid out and how, it can be very, very difficult to navigate for someone acting on their own, the CCB may be a better option. And then there's two other things I want to mention, and then I want to sort of see if Dana or Jeff think that I'm missing anything. There's attorney's fees. If you do have an attorney representing you, the CCB is generally not going to award you attorney's fees. They have the ability to in exceptional cases, if a party's acting in bad faith. But other than that, you're not going to get attorney's fees. And even if there is bad faith, there's a cap on costs and fees of $5,000, or I think it's even $2,500 if the other party's not represented by an attorney. Whereas in federal court, if you've got a timely registration, you can seek your attorney's fees. And I took a case to trial, some years ago where we got a $30,000 non-willful statutory damage award, and then we got 6 figures in fees when the defendant should have, because the defendant had no real defense and forced us to go through litigation. So sometimes like that's an issue. And the final thing is, not all cases, obviously not all cases involve novel issues of law or anything that is going to need to go up on appeal, or where really there's a lot of bread and butter cases where you're just applying the law and it's all pretty straightforward. But for those cases that aren't, and they do come up more often than you might think, your review options, if you think that the tribunal, if you think the CCB got it wrong, your review options are much more limited. You can ask the CCB to reconsider a determination if it includes either a clear legal and factual error or some technical mistake. But if they deny that, then your option is to ask the Register of Copyright to review that determination to see if the board abused its discretion, which is always a pretty high standard. Or you can ask a federal court to reverse or modify the CCB's determination. But in order to do that, you're going to have to show the federal court that determination was the result of fraud or corruption or misrepresentation, like really something more than just they got this wrong. Whereas if you proceed in federal court and you think the trial judge got it wrong, you can take that up to the Ninth Circuit Court of Appeal. Sometimes that ends up making new law, which isn't going to be an option out of a CCB proceeding. And sometimes, depending on what the issue is, the Ninth Circuit the Court of Appeal just has the ability to review things de novo, like on its own, and say, yeah, we think they got this wrong. Other times there's abuse of discretion, but it's just, you've got a much better ability to correct erroneous rulings. Again, at much greater expense, but you've got a much better, greater ability to correct erroneous rulings through proceedings that go, that get processed through federal court than through the CCB.
So let me give you a question that's already come up. How is willful infringement defined?
Willful infringement is defined as either knowing infringement or infringement with reckless disregard of the copyright holder's rights. So you can't, bury your head in the sand and say, yeah, I didn't know. Like if you should have known that you were infringing and you just kind of like turned a blind eye to it, that's going to be the same as knowing infringement, and it's going to be deemed willful.
So Dana and Jeff, you've both been through the process or watched the process that other people have gone through. Is it what you expected it to be, or have so far watching it, is it what you thought was going to happen?
Dana, you want to go, or I can go?
You go.
Okay. So we started working on this, we being the APA, in 2001, right? On bringing to life some kind of small claims procedure to allow visual artists to protect their rights. And so that's, I think the law passed in maybe 2018 or 2019. And so 18 years of work. Dana and Juliet and I and other APA members and members of other organizations, basically here in California, we went into our representative's office and, advocated for the members' rights, and we had pretty big plans for this. And of course, legislative activity, there has to be a balance, and people have opposing viewpoints. And you might think up a great system, but it's going to get whittled away by opposing forces who don't agree with what you want, or who are afraid that you might gain, let's say that creators and copyright holders might gain too much power out of the legislation. And there were significant opposing forces in this legislation. And so what was really looking like it was going to be great, in my opinion, turned out to be not so great, and in some cases dangerous. I'm case number 4 in the small claims. I tried to be case number 1 just because I worked on it for so long, and I'm not responsible for it. A lot of people worked on it, but I wanted to be case number 1, and somebody pressed the button before me. So I'm case number 4. I filed June 16th of 2022, and I'm in the middle of it right now. Okay, so it is not a short process. It might be simplified, but this is not like the small. If you've ever been in small claims court in your city or county, it's nothing like that. It's way more complex because copyright law is a complex thing with a lot of considerations. There's never a simple answer in a copyright dispute, and so it is. There are some things that happened along the way that are concerning, and I wanted to test it out, and a few of those Steve has mentioned. And one of those is, of course, that your damages are limited. So you get into, you want to go to small claims or the CCB, and you think, well, this person made, I know they made 100 T-shirts, so that's got to be less than $30,000. So I'm going to go to small claims. And you get in small claims, and you discover that they made 1 million T-shirts, and that they've sold T-shirts overseas, and there's all kinds of. They made posters, they made trade show booths, they made whatever. You can't get out. Once they, after the first 60 days, when they, once they decide they're not going to opt out, they have 60 days to opt out after you serve them, you're locked. You're not getting out. You're not going to get more damages. And so, well, let's just say under very limited circumstances, would you be able to get more damages elsewhere? And then there are other really significant issues. And of course, we fought for the ability to get out. If you learn in discovery in the CCB that the infringement's bigger than you knew, how are you supposed to know? So if you learn in discovery, you should be able to get out and continue it on into district court. Well, we didn't win on that. And the other thing we didn't win on that's rather significant is in federal district court, if you're eligible, if you've got a timely registration, you can go for statutory damages. Then you go through the whole process, and the court makes its decision, whether it's a jury or the judge. And after that decision, in that decision, you're going to learn how much the court has awarded you in actual damages and profits and in statutory damages. And then you pick whichever one you want. And most people pick the higher number, right? Because it's built into copyright law that you get to pick after they determine what you're awarded, not before when you don't know. Well, in the small claims, before they make their decision, you have to decide whether you want actual damages or statutory damages. And that's a real roll of the dice. And I'm sure Steve's going to talk about it, but in that one case that has gone through decision in the last year, there was $1,000 awarded to the photographer in damages after they spent hundreds, if not thousands of hours working on this, right? And so it's a rather big deal. To me, also, the injunctive relief is a huge thing. And Steve explained that really well. So if you want somebody to stop infringing, you're not going to stop them in the CCB. Only if they voluntarily say, okay, we'll stop doing these books, we'll stop doing these T-shirts, we'll take it off social media, are you going to be able to get them to stop? Of course, the CCB can take that into consideration when they calculate your damages. They're probably going to think about, well, what would your damages be going forward? Maybe. But they've shown that they're not very liberal in terms of the amounts that they award thus far in our one example. So it's somewhat concerning. You also can't bring a claim for removal or falsification of your copyright management information in the CCB. And that's problematic because usually that kind of gets combined with your infringement claim. And again, there's no willfulness consideration. They can't even consider whether or not an infringement was willful. And that's problematic as well. Not being able to get your fees and costs back or only under certain circumstances, that's a big deal. And also, these 3 officers, all good people, are dealing with very complex situations. District court judges with 30 years of experience struggle with fair use questions. None of these officers have been federal judges. They're good people. They're attorneys. They're very experienced. One of them was the general counsel of the Copyright Office. But fair use decisions are incredibly complex. Determining profits is an incredibly complex thing that you really almost, I could pretty much say it, that you can't do it without an economist or an expert to go in there and analyze whatever the financials are of the other side. And so there are all of these issues. On top of that, you might go in, as Steve said, pro per or pro se. I think they're both the same thing. Mean represent yourself, and your respondent, which is the defendant, might just bring an attorney in. So now you're up against an attorney, a client represented, an opponent represented by an attorney with years of experience. And what does that do to you? But they can't say no attorneys. That's just a little taste of what I think. I'm going to hand it over to Dana and I'll continue on.
Okay, yeah, I hopped on this. I had a handful of cases that I had discovered usage, or a service had discovered usage and they didn't want to pursue it in federal court. And so I grabbed them to basically kick the tires on this thing. And with mixed results and no final results yet. So out of the multiple cases that I've filed, the first one I filed, the person was an individual, and they basically got scared into settling immediately, which was okay, a nice outcome. And I was very fair with them on the settlement. I had another one that opted out immediately, but ultimately I was able to settle with them as well. Again, a very modest settlement. But it would, a lot of this for me, again, it was kicking the tires, and also the principle of the thing, don't be grabbing our pictures and using them. An issue that I've run up against is service. If you are not confident that you are able to execute service, it's a waste of time and money. And so I've had two that have been basically just the cases have been closed because I was unable to successfully serve the respondent. The ones that I have remaining, 3 of them are in default, various stages of default. Basically, the respondent has just ignored everything. They just are simply not responding at all and hoping it will go away. Whether it's lack of knowledge, or again, just a willfulness of, it's like la 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 la, put my fingers in my ear, I'm not going to pay attention to this. We'll see how this goes down. I had my first full default hearing last Thursday, which was an hour and a half long, and peppered with a lot of questions from the 3 people on the panel. And it's interesting, after having seen the modest award in the one case that has been concluded, I'm concerned about what the monetary awards are going to be. They were indicating to me that they were going to try and very expeditiously get their final ruling out. I was hoping to get it before today, but it hasn't shown up yet. But to Jeff's point, that while filing a case is fairly simple, it doesn't take a lot of time. As you go through the proceedings, and especially if you, like, again, I've got 3 default cases, and filing your default statement, and providing all the evidence, it's a time suck. And so if the awards are going to continue to be as modest as, again, we have one case to judge it on, so that's really not a great basis by which to make a judgment. But if they go down that same path, I question the validity of this for the time invested. If you've invested the amount of time I have on each case and you're only getting $1,000, that's not a very good hourly rate. we would be better off going and shooting a test for ourselves and getting some new clients. You know, it's a mixed bag, and the jury's still out on, you know, as far as I'm concerned, as to how beneficial and viable this all is.
Do they give you information on how you serve someone because it's different in each state? Do they help guide you on that?
Yeah, a couple things on that. One is that initially they still do, they offer pro bono services. So they're supposed to be teamed up with law schools and companies who are supposed to assist you pro bono to help walk you through that process. When I tried to reach out to some of their firms that they said they partner with, I got zero response, no acknowledgement whatsoever. So I'm skeptical as to whether that pro bono service is actually available. As far as service is concerned, if you've got a viable address, I have found, this is just my personal solution, I found an online service that is nationwide. I've got an account with them, so I can just send them the packet. So basically, once your case has been approved to move forward, you are given a service packet through the dashboard on the CCB website. And you basically just download that packet and you engage with a service agent. Now, it's the same as serving in any other small claims court. You can have somebody else do it. You can't do it yourself. You could have a sheriff do it. I just found it more expeditious to just hire a service. Services are anywhere, depending on the state, from $60 to $125 to execute service. And the place I found, I simply upload the service packet to their website and they just take care of it, as long as you've got a valid address where somebody can receive service.
And Stephen, if you were going through federal court, what would that process be like? Would that all be handled by the attorney who's taking it on for you?
Yeah, essentially the same thing. We have a number of different process service companies that affect nationwide service and know the rules in each state that they need to serve someone in. And it's effectively, that's what I understand that Dana's saying is, you know, using one of those services that we would use in federal court, just using them for the CCB is the easiest thing as well.
Jeff?
So I've been through the ringer on service in my case, and I just want to share my experience and hopefully some of you can benefit from it. So as was mentioned, you have to follow the rules, the law in the state in which you're serving. Every state has different rules and requirements. In some states, you can just send a registered letter. In other states, not. In some states, it makes a difference whether it's to an individual or a corporation. The rules are different in every state. In my case, I had in the state in which my respondents were, and there were 3 respondents, the CCB gives you a document to look at. It has a little summary, like 2 sentences about serving in each state. It's nowhere near enough information to make a decision. So then I had to go to Michigan state law and start working my way through the law to figure out what was required for service. And for those of you who don't know, if you're serving on a corporation, you have to serve their what's called agent for service of process. Is that
registered
right?
Agent.
What was that?
They're registered agent for service.
The registered agent for service of process, right? And so you have to go to the state, the department of that state that handles corporations, look up that corporation, make sure you have the right one, pull up their record, and it'll have a name and an address for service of a particular person at a particular address. It may or may not be at the address of the business or person that you're serving. And so you have to pay careful attention to that. If you serve to somebody else whose name is not on that form, you're going to get that service challenged, and it can end up with your case getting kicked out. So be careful about that. So I looked up the laws in the particular state and spent hours reading them, and I'm fairly familiar with litigation. It was a little bit complex for me, but what I got out of it was I could serve by registered mail as long as I limit it to the person. The only person who can sign for it is the person who I'm suing. And so I had somebody on my behalf, you have to have another person, as was mentioned, send 3 registered letters, the service packet that the CCB gives you to serve, to by registered mail with a limited recipient, and they were served, and the person at that company, the owner, signed all 3. And then I got that back, I turned it into the CCB, and we were off and running. But they waited for 60 days before they even looked at it, and 60 days later, just before the period expired for opting out, they contacted me and said, hey, you served corporation, and a corporation in the state that you served has to be served by a process server or in person. So, and they said, you have this many days or we're going to kick your case out. So they waited the whole 60 days to even look at it. So then I called the sheriff in that place, near where this business was, and paid the sheriff to serve these papers, right? So the sheriff goes over to that location, knocks on the door, somebody answers, and says the owner isn't there, but that they're authorized to accept service. So the sheriff has them sign it and sends the stuff back to me, and I turn it in. The CCB says, well, on line 3C, they needed to put this, and they didn't do it, so you have to do it again. So there I am again, right? And so I do that, and then roll forward, and I'm also in a default situation, which means in a default, it's just when the respondent, who is the same as a defendant, does not respond to the court or fails to do something like submit their response, which is the same as an answer, or register for the ECCB, this sort of thing. They didn't for like 230 days. I waited, for them to do it. They didn't, so then I'm in default, and then finally they show up 230 days later with an attorney against me, right? And the attorney says, well, they served it on this person in our business that's not the same name as the person who's on our agent, who's listed as our agent, so it's an invalid service and you need to kick this case out. And so that motion is currently before the ECCB. So it's not for the weak of heart, the service process, and I would highly recommend, don't do it yourself, don't do it by mail, do what Dana says and do what Steve says, which is find a service and just pay them. They will look up the right agent, they will serve it, they will get everything signed right, and they will get it back to you in a timely way, if it's possible to serve that, or some people evade service quite effectively, as Dana said.
If it's a California defendant, you can serve them by certified mail, but you got to make sure you know what the rules are of the state you're working in.
And if it's wrong, the CCB tells you it's wrong. That's who.
Well, that's what Jeff was saying, is that you've got 60 days to effect service. They basically waited until the end of the 60 days to tell him, hey, you've got a problem and you need to redo this in the next couple of days. It's like,
right.
Okay, great.
Right. It was just nerve-wracking. Absolutely.
It's hard to know how much of this is just sort of growing pains of the CCB figuring out how to get its operations working smoothly, and how much of it is sort of systemic. I don't want this to become like a whole, poop on the CCB thing, but I will note that, Dana was saying, look, getting your complaint filed is easy, and then you got issues. As getting your complaint filed is not always so easy. I've handled literally thousands of copyright cases in federal court. Literally thousands that I've filed complaints on. I've litigated the sufficiency and the adequacy of complaints through the Ninth Circuit, through the I've got published opinions on what is what needs to be in the pleadings and what's the appropriate standard. So, generally speaking, I know of what I speak. I filed a claim in the CCB that said in no uncertain terms that the defendant had used a verbatim copy of my client's photograph on its commercial website without authorization, and they said, well, that's too conclusory, and they sent it back and they said, this is not adequate. Now, this doesn't happen in federal court, right? In federal court, you file a complaint, the other side might challenge it once they get served and say, hey, I don't think this is sufficiently pled. But the court doesn't on its own say, I don't think this is adequate. The CCB came back to us and said, we don't think this is adequate. Okay. I submitted an amended complaint along with images, my client's photograph, the photograph on the offending website, and some additional language. They rejected it again because my client didn't realize that the copy of its photograph that it sent us had been slightly cropped. And so the CCB, whoever reviewed it for the CCB, actually did a close enough comparison and realized that the copy in the article was a little bit wider and thus had the stuff that wasn't in my client's photo, and therefore it couldn't be a copy of my client's photo, but in the rejection letter then acknowledged that they were able to go back and look at the deposit material and see that the deposit material did match what was on the website. And so, like, if we are alleging, we could allege that. And I'm like, why? And I went back to my client with this. My client's like, let the CCB claim get dismissed. Let's refile in federal court. This is nonsense.
So I have
Okay.
a very complex question here from someone. So I'm going to ask that, William, if you will, I'm going to allow you to talk, and if you could ask your question out loud, if you don't mind. I've just put you on.
Okay, can you hear me?
Yes.
Yes.
Hi, guys. Thanks so much for doing this. Yes, my three questions were, one, what are the rules on images being time barred? I think SDNY ruled about 10 years ago on the ability to only include infringements in the last 3 years. That's one.
Yeah.
Okay.
Good.
Okay, two is, can you talk a little about the questions you were asked during discovery? Like, I have no idea what they're asking you to prove. You know, they've stolen your image and used it when they were never had any kind of license for it. And then what do they ask you? Do they ask how much you normally receive, why they should pay you because they found it online, et cetera? And three, if you have an infringement, I would expect to get considerably more compensation than if they had licensed the photo correctly, especially with no credit. Getty and Corbis used to always say they would demand 10 to 20 times the amount. How will this hold up in CCB? Obviously, the infringer didn't sign a contract, but just stole the images.
So there's a lot there. Let me kind of get through some of this as quickly as possible, and I'm sure Dana and Jeff are going to have some thoughts as well. So, with respect to images being time barred, that statement, images being time barred, is a little bit of a loaded statement that there's not really a clear answer to. I think what you're referring to is the ability to seek damages on infringement claims where the infringement occurred more than 3 years before. Prior to the Supreme Court, prior to the Supreme Court ruling, I don't even remember what year it was at this point, but most jurisdictions have what's called a discovery rule. I'm just going to keep this sort of high level. The discovery rule is a rule that says that, so let me back up just a step more. The Copyright Act has a 3-year statute of limitations, which means you need to bring a claim within 3 years of when the claim accrues. The discovery rule is a rule that defines when a claim accrues. Under the discovery rule, a claim doesn't accrue until someone knows or has reason to know about it. Okay? The New York, California, just about everywhere that considered the question had said had applied the discovery rule to copyright claims and said that the claim doesn't accrue until you know or reasonably should have known about it. So let's say you 6 months ago you used reverse search technology and you found something that had been posted in 2018, and you just learned about it, and it's not something you reasonably could have known about earlier. Under the discovery rule, that claim would still be timely. Now, the Supreme Court in the Petrella case, which dealt with the Raging Bull movie, that was a claim where the plaintiff had known about the claims for like 14 years before she filed suit. And and what was at issue in that case was this doctrine of laches. Laches is it's a legal defense. It's an equitable defense that says, oh, well, you've waited too long. And in Petrella, what the Supreme Court said is there is no laches defense in copyright claims, but the Copyright Act says that you can go back 3 years and only 3 years in seeking damages. What the Supreme Court did not say is whether or not the discovery rule was still valid. It specifically recognized that most jurisdictions follow the discovery rule. Or if it is still valid, what does that mean relative to the three-year statute? And so since then, there was a case in the Second Circuit, basically in New York, the Sohn decision, which said that we read the Supreme Court's holding in Petrella as saying you can only go back 3 years on seeking damages in an infringement claim. Now, if someone continues to use your work, can you sue them and seek injunctive relief more than 3 years later? Are there other remedies? Like perhaps, like we haven't seen a case addressing that in New York. But after the court of New York rendered its decision in Sohn and said, look, you can only go back 3 years on damages, which really hurt a lot of photographers' claims that had to be brought in New York, the Ninth Circuit addressed the same, here in California, addressed the same issue and said, we don't think that the Second Circuit got it right in Sohn. We think that under the discovery rule, as long as you didn't know or have reason to know about the claim more than 3 years beforehand, you can still go back, and seek damages on those claims. And the Supreme Court in Petrella was really only addressing a situation where you knew of the claim more than 3 years before you brought it. And then more recently, it was it the Fifth Circuit or the Seventh Circuit? Like I think it was it was the Seventh Circuit, wasn't it? That another circuit just recently came down and sided with the Ninth Circuit as well and said, yeah, we don't think the court got it right and so on. So what you're addressing, William, is what you're asking about is it's not images being time barred. It's whether and to what extent you can seek damages on infringement claims that commenced more than 3 years beforehand. And even in the Petrella case, just to be clear, even in the Petrella case where the Supreme Court said you can only go back 3 years, because that dealt with a movie that continued to be exploited, right? Whether it's like downloads or whatever, there still are some damages within that 3-year limitations period that you can recover. And so if someone's selling reproductions of your print and they've been doing it for 10 years, even if you're limited to going back 3 years, you can still seek damages for any of those, like those sales or whatever that happened over the last 3 years. So again, your question about images being time barred, it isn't really the right question, if that makes sense. So there's a lot there. Before I go on to anything else, William, did that make sense? And Dana and Jeff, anything to add to that?
He's no longer on
Jeff
the.
does.
Okay. The only thing I would add is that I think you said it. It depends on where your case is. So you have the Supreme Court, and that decision applies across the land, but the different circuits are interpreting it differently. So you could have one decision in the Ninth Circuit, which is West Coast, and that's going to be different than if you're in Michigan or in Ohio or wherever on whether or not you can have your damages have a look back, which means beyond the 3-year period. But in any kind of legal dispute, you have a certain amount of time once you know about it to move forward. And it's not you shouldn't sit on your laurels, because you're going to lose the opportunity to pursue it and attempt to get a remedy. And to use William's word, you'll be barred from seeking a remedy for that infringement.
And I'll very briefly hit William's question about the amount of damages. I can only speculate at this point, again, because it's still so early in the game. Based on this first case that's been closed out, I am skeptical that you're ever going to see anything like 10 to 20 times what your licensing fee is going to be. I had the conversation with Stephen, what are we calling them? The people on the panel?
Officers.
Officers, thank you. I had the conversation with the officers about this exact topic on last Thursday, basically pleading with them to, I was asking how they came up with their final figures, and they were not willing to discuss specifics, certainly about my case, or, they really weren't even willing to go very general with it, but they did acknowledge the concept that the award should serve as a deterrent for people to infringe. And because there were a lot of questions asked during my hearing about what a normal licensing fee would be, what did it cost to produce the image, and looking at those costs, were those reimbursed expenses, were those creative fees, were those licensing fees? And it felt very much like they were going to discount reimbursed expenses. So if you're talking a photo shoot and the client pays for talent, they pay for the location, they pay for props and wardrobe, they really were narrowing down on what were the licensing fees, what were the creative fees. But they seemed to grasp that it couldn't just be, the award couldn't just be the same amount as if they would have licensed it legitimately, as William was talking about. But what that is, we don't know yet. We don't know what multiplication factor they're going to use to judge that award. But I would be skeptical that we're looking at a Getty or Corbis 10 or 20 times.
Well, one of the things that I want to make sure that we're clear about in answering William's question is there's an assumption in there that he has a timely copyright registration. If you don't have a timely copyright registration, if you don't have a registration that predates the infringement, subject to this, 90 this limited safe harbor, then all you can get is the reasonable licensing value of the photograph or the profits that the other side made off of it. You're not going to get any multiplier at all. What Dane is talking about very sagely is that assuming that you've got timely registration, then the law is clear that the purpose of the statutory damages that you can seek by virtue of that registration are not just to compensate the defendant, but to punish and deter infringement and serve it. So and now you get into this question of, okay, well, what is the appropriate amount, that the appropriate percentage. There have been quite a few judges across the country in awarding damages that say, well, we think that in cases even of willful infringement, 3 to 5 times is sufficient. On the other hand, there have been plenty of default cases that I put in front of judges where those judges have said, well, the other side didn't answer and there's the purpose of statutory damages, and we've gotten plenty of $30,000 default judgments. I mean, most of which will never be collected, but so it really just depends. And when we talk about whether to use the CCB or federal court, one of the things that I didn't mention before is really who's going to be deciding your case. And there are some judges that I know are going to say, well, you need to prove up, right? And I'm going to kind of, before I say what I was going to say, I want to kind of look at, Juliet had also, had written, or how do you prepare yourself for the CCB? Or how do you prepare yourself for federal court? And you need to make sure that you're putting forward, competent evidence to the extent you have it of your licensing rates and your licensing fees, because that is going to be part of the equation. But then beyond that, in theory, the judge or the tribunal or a jury should then decide within that statutory range based on the facts of the case, not just your licensing fee, but what's the indicia that these folks, that the defendants either thought they could legitimately use it, or was this some gross willful infringement where they asked and you said no and they said screw you, I'm going to use it anyway, or like what are those facts? And that should affect the amount the amount that's going to be awarded. But it's always been my view, even in federal court, it's always been my view that I would never try a copyright infringement damages claim to a judge. In my view, you are always going to do better in front of a jury. A jury who is simply, realizes that, hey, my job is to right or wrong here, and this is not acceptable, as opposed to a judge or a tribunal who sees, hundreds and hundreds and hundreds of copyright cases and just says, these small value cases are taking up all my time and I don't want to encourage them. And I'm not saying they all think that or say that, right? But to Dana's point, we'll see what the CCB ends up doing. But if you're really concerned with getting a decent multiple and not just being tied to, a small multiple of your licensing rates, assuming that you've got timely registration, that may be a reason you might not want to go to the CCB.
Can a case get kicked from CCB up to federal court or from federal court to CCB by?
Only from federal court down. I don't think they can't push it up.
Right.
Right.
I mean, well, you can push it up by a defendant refusing the CCB.
Right.
And, we've talked so far about why a copyright holder might want the CCB versus federal court. We haven't really talked about why a defendant would want the federal, want to accept the CCB or reject the CCB.
I want to comment on actual damages before we move on.
Oh, sure.
Okay. So actual damages are just that. It's actual damages. There's no multiplier. You don't get more than you would have charged. You get the amount that you would have negotiated with that company or person if they would have approached you in advance and licensed it from you. There is no additional money that's going to be given to you, and so or awarded to you. And there are different ways of determining that, but that award, an actual damages award, can't be what they call punitive. It can't punish the infringer for infringing. That's where statutory damages comes in, and Steve's already explained that, so I won't go there. But I do, a lot of photographers are, they make some assumptions that are incorrect when going into any sort of legal procedure, and be really careful. So your history in licensing is going to come to the fore in your case. The other side, to answer another one of William's questions, is going to say, I want to see your licensing transactions, all of them, for the last 5 years or whatever period the officers deem reasonable. They might also say, I want to see your income tax statements for the last 5 years. And I want to know which part of that is licensing or not. And I want to see if you've licensed microstock or royalty-free stock and what your royalties are for similar usages. And I want to see if you've ever licensed an image for unlimited use. I want to see what that fee was. Have you ever walked away from your copyright and assigned it to a client for some fee that's $200, $500, $1,000, $5,000, whatever it is? If you walked away from your copyright for $1,000 and this defendant only used it, or I wouldn't say only, this defendant used it, in a display in their store, that's a lesser use than the value of your copyright. So a savvy defendant or respondent is going to ask for those things, especially if they're protected, if they're being represented by an attorney. Your income tax statements, all your licenses, all your royalty statements, any copyright transfers, all that, and then the court gets to see that. And when you supply things, your settlement agreements are likely going to get disregarded by the officers. And I say likely because it's not certain, but those don't prove necessarily what you would have charged in an arm's length transaction to a company or a person who would have come to you in advance, because you have leverage in those settlement negotiations. There are instances when courts allow the consideration of those, and it depends on the circumstances, but you have a lot of leverage in settlement negotiations. So, I've seen photographers repeatedly put forward, well, I got this amount, $10,000 for this, and $30,000 for this, and $50,000 for that, and $10,000 for that. And all those are settlements. And then their actual licenses are $200 and $500 and $1,000. The officers are going to see through that. So you need to be pretty careful there. Your fees are going to be, your actual damages are going to be determined by a few things. One is, what would you have charged for the usage in question if it was not an infringement? And that's based on your licensing history. And if you have no similar licensing history, then you can look at market rates for that type of usage. And I'll tell you, market rates are not very high right now for broad usage. And that's a difficult thing to do when you don't have an expert to come in and say, okay, this is what the market rates are for this type of usage, and do some calculation, which you don't have usually in the CCB. Another thing they might consider is, did this usage damage your ability to license this to others? You can make that argument, and you might be able to make it successfully, but really hard to prove how much the value of your work was damaged, to put a dollar number on that in front of the CCB or any court. And lastly, they might consider if you were damaged in some other way that's not monetary necessarily. That could be your reputation or something like that. And that's actual damages. And as I said, profits are really a tough call in the CCB. It's a very complex situation. And, you know, for all you know, they could award you $750 in statutory damages, even if you have a timely registered image. And they might have awarded you more actual damages than statutory damages, but you'll never know because you have to select it in advance. So not an easy question.
Yeah, let me sort of take issue with one thing that Jeff said, just in a limited context. Profits are not always that hard to get. If the law is actually pretty favorable for copyright holders in that regard, if someone's selling t-shirts, now you do have to make sure that they're not also selling sweatshirts and hats and hoodies and all the other stuff. But if you know what someone's selling, the copyright holder only has the burden to show the total revenues that they derived from the sale of infringing product. And then the burden shifts to them to show deductible expenses, apportionment, whatever else. And it's really a harder burden on them. And so it's a, like those aren't, sometimes those can actually be really good and reasonably easy claims to pursue. But in other cases, you know, where you do really need to kind of get into the financials of it, they can be a bit more difficult. I think we're running out of time. Is that right, Juliet? So let me end with this. It's been really clear for a long time that there are a lot of smaller cases that could benefit from basically a copyright small claims court. There are cases where someone doesn't have a timely registration and can only seek their actual licensing fees, and it just doesn't justify an attorney spending, you know, $20, $30, $40, $50, $100,000 worth of attorney time to litigate the case. Probably the biggest problem with the Copyright Claims Board is that the cases that make the most sense for photographers and, you know, rights holders to litigate in a small tribunal make the least sense for the defendants to agree to litigate. I had a case some years back where our client discovered a tank top with their artwork on it. It was a single $10 tank top, and we didn't have any evidence of anything other than that tank top. And the defendant claimed they lost all their records and blah, blah. We had a $10 tank top. Because this was before the CCB, and because I probably wouldn't have litigated in front of them in front of the CCB anyway, we took the case through trial. The jury concluded willful infringements, awarded $40,000, and then we got some fees on that. That wouldn't have been available in the CCB. And so, you know, the claims where we have timely registration, where we don't really know if there's willfulness, where there's a potential for it to be worth more than that $15,000 per work max, are the ones that we say, probably not the ones for the CCB. And when our clients come to us and they don't have timely registration and there's limited value, I say, you know, this is a great CCB claim. But if you're a defendant, especially one of these big media companies that get sued a lot because you use a lot of people's artwork or it's been put up there by your you're potentially subject to a lot of claims. If you know that there's no timely registration and you know that an attorney is very unlikely to take this case in federal court, and you know that if you then opt out of the CCB, it's very unlikely that you're going to face this claim later on. Those smaller cases are the ones that make the most sense, are unlikely to actually be able to get resolution in front of the CCB. And even if they are, to Dana's point and Jeff's point, you know, the effort that you're going to need to go through, is it worth it? Now, I remain hopeful that a sweet spot can be found where the CCB makes sense. And we'll see what happens. For now, we'll just say, happy birthday, CCB, and we're rooting for you.
Thank you. I love that ending. That's great. I really appreciate having this conversation today. For those who are here listening, if you're interested in hearing more of these, we are doing them every month. There is also a series on our YouTube American Photographic Artists channel Also, I'm always looking for people to be involved with advocacy and APA. So reach out to me if this is a subject you love talking about all the time and you want to participate with decisions that are being made about how we're going about affecting laws, changes, whatever it is. So I really thank you so much to Stephen Doniger, Dana Hersey, Jeff Sedlick. Really appreciate your being here today. Thank you. Thank you for those who are listening, and join APA because it matters.